そして続きまして、特許権に対する無効・異議制度の実情について、引き続き先ほどの3名の方に順にご講演をいただきます。はじめは特許庁、安田太審判部長です。それでは、安田審判部長、どうぞよろしくお願いいたします。
はい、それでは続きまして、特許権に対する無効異議制度の実情についてご紹介いたします。まず最初に使用統計でございます。こちらがここのところの無効審判、それから異議のですね、申し立て件数になります。無効審判につきましては100件ちょっとで、若干下がり気味ながら横ばいというふうに見ております。それから異議につきましてはですね、2015年4月に制度開始されましたけれども、その年は少し少ないんですが、それ以降ですね、大体1000件ちょっと、1200件ちょっとということで推移してございます。それから平均審理期間でございますけれども、これ、無効審判につきまして、少し伸びているのは、おそらくですね、当事者同士のやり取りのですね、影響がコロナの影響が出た関係で、少し伸びたのかなというふうに思っております。一時的なものかもしれません。それから異議につきましては大体 7.4 月ということで推移しております。これ日米欧の比較になります。制度が違いますので、単純には比較できませんけれども、規模感ということで見ていただければと思いますけれども、EPO はですね、異議、これは異議部ですね、異議部があって、そのさらに上に審判部があるんですけれども、異議部に対して申請があるのが大体3000件ちょっとということでございまして、USPTO につきましては、これは当事者系ですね、主に黄色の IPR、当事者系レビューですけれども、これが1500件ぐらいございます。から JPO は先ほど申したとおりでございます。これは日本の無効審判における審理結果の動向でございまして、ちょっと見にくいんですけれども、数も少し減ってきてますが、一番上がですね、一番上の黄色が無効になったもの、それからその下のですね、灰色のところがですね、訂正があったと、訂正があって無効にならなかったもの、それからその下のベージュのところがですね、訂正なしで無効にならなかったものということで推移しておりまして、特徴的なものはちょっと見出せませんけれども、大体ですね、無効になる割合がですね、2割ぐらいで推移しているかなというふうに見ております。日本におきます特許異議申し立ての処分状況、これどうなっているかということでございますが、訂正があって維持されたものが 50% ちょっと、それから取り消されたもの、これ11% でございます。で訂正がなしでですね、維持されたものも37% ぐらいございます。これは異議が始まってですね、2015年の異議が始まってからのすべての統計となっております。参考までに欧米のですね、処分状況についても紹介いたしたいと思います。これ、後ほど紹介があるかもしれませんけれども、EPO、それから USPTO、制度が少し違いますので、EPO については異議、それから USPTO については IPR というのが主体でございます。で実際取り消しになる割合でございますけれども、これEPO もですね、USPTO も大体4分の1ちょっと、日本が先ほど 11% だったと思えばですね、少し多めかなというふうに思っております。それから日本でですね、おける特許異議申し立ての状況で、これは分野別です、IPC 別に見たものでございますけれども、日本の特徴としましてはですね、割合的に高いのがですね、C、化学、知金になりまして、これが 1.2% ですね、全体に占める。で続きまして、これ、数は少ないんですけれども、D セクション、繊維、紙といったところが高い割合となっております。これ欧米についても少し見てみたところですけれども、どの分野が多いかということでございますが、EPO につきましてはですね、機械、それから化学が多いということでございまして、USPTO につきましてはですね、電気、コンピューター、それから機械、ビジネス法が多いということで、分野がですね、全然異なっておりまして、この点、大変興味深いかなというふうに思っております。あと異議とか査定不服で無効ではありませんけれども、拒絶査定不服審判が参考までどうかというところでございます。これ青いバーですね、これが全体のその申し立て、不服件数の申し立て件数で請求件数でございまして、黄色がですね、 審判部で取り扱う件数になります。前置審査がございますので、補正があった場合は、審査部門でですね、登録になれば、その分は審判に上がってこないということで、青と黄色の差分が出ておりますけれども、審判部に上がってくるのが、7500件ぐらいというのが最近の状況でございまして、平均審理期間としましては、11ヶ月、11.9月ということで、ほぼ横ばいというふうになっております。拒絶査定副審判の請求成立率でございますけれども、こちらはですね、昨年で言いますと、76.8 ということで、緩やかに上昇してきているという状況でございます。それから以前よく騒がれたパテントトロールとかございまして、外国企業が絡んでいるものについては、もしかすると異議とか無効が多いんじゃないかという観点で少し見てみたんですけれども、意外にそうでなかったということでございます。これ、異議でございますけど、灰色の折れ線グラフ、これは外国人の特許権の登録割合を示しておりまして、大体2割でございますが、棒グラフのですね、青いところがですね、非請求人が外国人というところで、平均のですね、登録率よりも異議の申し立て率が低いということで、ちょっと意外な感じはしますけれども、外国関係の異議は少し少なめということでございます。じゃあ、無効についてはどうかということでございますが、これは大体ですね、3割ぐらいということで、もちろん日本において外国人同士で争う場合もありますし、日本人と外国人が争う場合もありますし、逆のパターンもあるということでございますけれども、大体3割ということで、これもですね、特に先ほどの登録割合が外国が2割ということから見ればですね、取り立てて顕著な傾向はないかなというふうに見ております。一方でですね、拒絶査定副審判について言いますとですね、これはかなりの割合で、外国の方の出願が申し立てられているということで、2割をいずれも大きく超えていて、4割、5割に迫る割合でですね、拒絶査定副審判の割合が多いと。これは当然といえば当然かもしれません。外国出願に対して非常にお金をかけている結果ですね、最後まで権利化するんだという、そういう意思の表れではないかというふうに見ております。それから次ですね、審決がですね、取り消し訴訟として裁判所に行く件数、それから割合ですね、結果の割合でございますけれども、まず出訴する件数が左でございまして、無効と異議が合わせたものがですね、青になります。それから拒絶査定副審判に対する出訴がオレンジ色になりまして、大体ですね、ここには書いてありませんけれども、無効審判を結果に対して出訴する割合が5割ですね。それから異議に対してですね、異議の決定を不服として出訴する割合が 8%、それから拒絶査定副審判に対して出訴する割合が 2% となっています。でその結果ですけれども、こちらの右側にありますけれども、審決の取り消し率ですけれども、無効にいたしましても、拒絶査定にいたしましても、大体年によって変動はありますが、3割前後で推移しているかなというふうに見ております。それからダブルトラックでございます。これは裁判所とですね、特許庁で同時にパラレルに審理が行われている案件がありますので、その結果を分析したものでございますけれども、まず右の円グラフですけど、同時に起こった場合ですが、どっちが判断が先に出たかということでございます。これは73% が審決が先ということでございます。判決が後なのが先なのが 27% ということでございまして、あと一致率ですね、これは関心あるかと思いますけれども、無効の場合ですね、無効で、両方とも、これは丸だったと、特許庁も無効ではないと、裁判所も無効ではないというのは 63%、あるいは×だったものが 18% ということで、一致している割合が8割になります。で地裁とですね、それから特許庁で判断が分かれた場合が残りなんですけれども、その残りについてですね、分析したところですけれど、要は特許庁の審決を取り消してほしいというその裁判 でですね、どうなったかと、審決が間違っていたのかどうかという観点で分析したのが左上のちっちゃい円グラフになりますけれども、その結果ですね、審決が取り消されたものはですね、13% と、濃いベージュの色 13% というふうになっております。次ですけれども、本日のですね、パネルのトピックであります、訂正について、紹介したいと思います。これは主にですね、3条の比較も少し、後で述べたいと思っています。日本における訂正要件、これご案内の通りかと思いますけれども、訂正要件というのがございまして、ここにある括弧1、まず目的ですね、4つの目的を満たしている必要があるということ。それから括弧2ですけれども、これは今回のまさにパネルのトピックそのものでございますけれども、新規事項の追加を禁止しております。じゃあ実際どのぐらいの割合で新規事項の禁止がされ、これを満たしてなかったのかというと、ここにありますけれども、パテント誌という雑誌でですね、調査がされてまして、85件のうちですね、75% は、の訂正がですね、新規事項に該当しない、つまりOK だということでございまして、これに引っかかるものっていうのは、割合的には4分の1弱ぐらいということでございます。であと、無効審判ですね、訂正審判じゃなくて、無効審判における訂正請求のタイミングになりますけれども、2回ありますと、この絵でいうと、赤丸で囲ってあったところですね、その請求人からですね、権利者、被請求人に請求書が送られたときの答弁書との同時で行うものが1回目、それから口頭審理を得ましてですね、権利者に不利な結論になる場合はですね、必ず審決の予告ということを行いますので、そこでですね、再度訂正のチャンスがあるということでございます。答弁と弁白はこれ複数回行うことがありますので、もしかするとこれ以上に増えることもありますけれども、基本はですね、最大2回ぐらいということでございます。あと、これ訂正の要件の比較でございます。これ、実態要件でございます。基本的にはJPO の欄で見ていただきますと、下から2つの点ですね、新規事項の追加、それから実質的な拡張の変更不可という点はですね、EPO、それから USPT も同じというふうに言えると思います。で目的ですけれども、日本の場合、少し広めですね、ここにある4つの要件を満たしていればいいということでございますが、US と EPO につきましてはですね、審判に関係するところが必要なんだということかと思います。少し目的が違うというふうに思います。それから訂正ができる期間でございますけれども、JP は先ほど説明しましたように、複数できるということと、1回以上ですね、権利を取り消される場合は2回以上あるということでございます。から US につきましてはですね、訂正可能な期間については、審理開始後3月以内から訂正可能回数につきは原則1回となっています。それから EPO につきましてはですね、この訂正可能期間につきましては、おそらく後ほどですね、EPO から説明があると思いますけれども、2020年の規則改正がございまして、審判手続きが進むにつれて、徐々に制限されるということになっているようです。それから訂正の回数につきましてもですね、これは裁量ということでございます。最後でございますけれども、予備的請求、これは何かというとですね、第一規模のクレームを主として提出して、第二規模のクレームを提出するという、そういう請求ができるという制度があるかないかについては、EPO はあるということでございます。それから最後のですけれども、訂正のですね、拒否結論との関係でございますけれども、少しここ違ってまして、訂正ができるかできないかっていう話とは関係なくですね、訂正を認めた上でですね、無効と訂正と一旦認めた上で無効とするということがあるのが日本でございまして、US とですね、EP につきましてはですね、もうあらかじめ無効の結論であれば訂正そのものを認めないというような運用になっているということでございます。この点につきましてですね、今後のこの後に行われますパネルディスカッションでですね、議論できればというふうに思います。はい、私からの説明は以上になります。どうもありがとうございました。
安田審判部長、ありがとうございました。それでは続きまして、米国特許商標庁特許審判部、スコット・バーリック首席審判長です。それではどうぞよろしくお願いいたします。
All right, thank you. So I'll discuss the systems in the USPTO at the Patent Trial and Appeal Board. Starting with appeals, so one thing to know about both appeals and trials at the PTAB is all of our decisions are made by panels of 3 judges. That's required by our statute. And there's no jury, it's 3 judges. The judges are required to have both technical and legal training. For appeals, you can see about a decade ago, we had a very large inventory of appeals. And this had built up rather rapidly starting, by 2010, the number of appeals had been going up pretty steadily for a few years. It really reached its peak around 2012 before we were able to start hiring and to bring the appeal backlog down. You can see that through some tremendous effort by my colleagues at the PTAB, over many years, we're now under 5,000 appeals in our inventory. And that's about where we want to be. This slide shows the pendency of the decided appeals. And it's broken out. The colored bars are by technology, and the overall pendency on the far right with the black bar shows that we're now at an average pendency from the time that the board receives the appeal and dockets it to decision of about 12 months, which has been our goal for a long time. The slightly faded gray bars behind shows what the pendency was a year ago for the same time period. So this happens to be June to August of 2022 in the foreground with the colored bars, and in the background with the gray bars is last year, 2021. You see for most of the technology centers as well as the overall pendency, it's come down. We've had a slight increase in the biotech, not by too much, by about 1 month, but most of the other technologies have come down. So we're very pleased with where the appeal pendency is now compared to where it was. This just gives you an idea of the appeal intake in our fiscal year 2022, what technology centers were the most popular, and you can see that there are 4 categories of electrical and computer appeals. This is broken down by the technology center in the USPTO, where the cases are examined. So this maps to the examining core. But you can see that if you add up those 4 blue bars, that is the largest number of appeals, but followed closely by our mechanical and business method appeals, then chemical, then biotech. And then we have a small number of design appeals, and also the central re-exam unit. Those are from both re-examination and reissue of already issued patents. So this is another way that issued patents can be reviewed. They can be reviewed in the post-grant trial system that we're about to talk about, but third-party requesters can also request a re-examination. That's been something that has been possible since around 1980, so that's a long-standing way of requesting a review of an issued patent. Appeal outcomes, this is outcomes of appeals at the PTAB. So you can see that the examiner is reversed about 34% of the time completely. There's a partial reversal, partial reaffirmance in about 9% of our cases, and most of with the exception of a few small cases in administrative remands or dismissals, which doesn't happen happen very often, then the examiner's affirmed about 55% of the time. So that just shows you across the board for last year the outcomes of our appeals. This is actually very similar if you look at our prior year statistics. This is very common. It's broken down very similarly in prior years. Now we'll talk about the AIA trial proceedings or post-grant proceedings. There right now are, well, really two main types. There's three active types of AIA proceedings that one can initiate. The first is post-grant review, or PGR. That one has a limited window of time. You only have 9 months from the issuance of a patent to request a PGR, but the number of challenges, the grounds on which you can challenge the patent, are broader than in the inter partes review, or IPR, which by contrast can be used to challenge a patent at any time during its life after that initial 9-month period. But it can only be challenged on a limited number of grounds, as we'll see in a moment. There's also something called a derivation that is used if someone has derived their invention from another. It's not subject to a lot of the same time constraints that the PGR and IPR are subject to, and there's only a small number of these, but it is another AIA proceeding. There was a fourth kind of proceeding that is now sunset. It was called a covered business method review, but that proceeding has now sunset. No new covered business method reviews can be filed, although there are still a few that may be pending on appeal to the Federal Circuit or on remand from the Federal Circuit, but we're largely done with covered business method reviews. So what is the scope of each of these the two main types of AIA proceedings? So in the IPR, you can only petition based on anticipation or obviousness grounds, what we call 102 or 103, corresponding to the different sections of our statute, and only on the basis of prior art consisting of patents or printed publications. So that's it for an IPR. Post-grant review, you can pretty much petition on almost any ground of invalidity except best modes, or a couple of others like on sale bar and some others that you can't use. The main ones, though, and what this really means practically, is you can have a petition on patentable subject matter, or 101, or some of our written description, or grounds for indefiniteness, what we call Section 112. So those are the more common grounds in the PGR, because it's something you cannot get in an IPR. The standard for initiating review is slightly different between the IPR and the PGR. The IPR is a reasonable likelihood that a petitioner would prevail with respect to one challenge claim. That means that it's maybe 50-50, but it doesn't have to be exactly. It can be close, but the PGR is higher. It's more likely than not that one claim is unpatentable, or there's another way to get a PGR initiated if there's a novel or unsettled legal question important to patents or applications, although that ground is really not very frequently used. The standard of proof is lower than the clear and convincing evidence standard required to prevail in the U.S. District Court. That's by statute, so Congress designed the system so that the PTAB has a lower standard of proof than the District Court. Congress also provided us with some set timelines that we need to meet, including completing our trials within 12 months of institution. They can be extended by 6 months for good cause. But so generally, the entire time of an AIA trial, from the time the petition gets filed to the time that we're done, is about 18 months or less, but it can go slightly longer. The AIA proceedings really go in two main phases. So the first phase, what we call the institution phase, you can see in the red box, and that is about a total of 6 months average from the time a petition's filed till a decision is made to either proceed with a petition, to institute a trial, as we say, or to not institute a trial. If the board decides not to institute, that decision is non-appealable, although that hasn't stopped many parties from attempting to appeal or find some other way to get that decision reviewed by the courts. But if we do institute a trial, we move into the blue box, the trial phase, which includes a portion for amendments, which you heard about a little bit in the prior presentation. There's also a limited discovery period. There's an oral hearing and a final written decision. All of that has to take place within 12 months unless there's good cause, in which case we can extend for up to 6 months that trial phase. So what are the sources of law? First of all, we have our reviewing courts, the U.S. Supreme Court, and our immediate reviewing court, the U.S. Court of Appeals for the Federal Circuit. We have statutes that govern IPRs, PGRs. We have rules that we have put into place for the conduct. We have precedential decisions. We have a trial practice guide that gives guidance to the parties on how to conduct a trial. We also have director guidance and memos that the director can issue, and I talked in the prior time about some of the efforts that Director Vidal has underway right now to try to provide additional clarity in our proceedings. So the outcomes of a proceeding, if we do institute trial and we go all the way to a final written decision, what can happen? Well, really 3 things. One, we'll find all the claims are patentable, so we uphold each and every challenge claim. There's a mixed result where some challenge claims are upheld, some are not, or all the claims that are challenged are found unpatentable. So that's really the 3 results. You'll see in just a moment I have a few statistics on this. It's available on our website if you'd like to go look. So what can happen, what can a patent owner do if they get an unfavorable final written decision? There's a couple of things they can do. And by the way, a petitioner can have similar options if they get an unfavorable final written decision. So they can ask for panel rehearing. We talked about this previously, but they have to choose panel rehearing or director review. There's also still a proceeding we have that's called a precedential opinion panel. That's another route. Or they can just go and appeal to our reviewing court, the Federal Circuit. So here are some statistics. First of all, and again, as you heard in Mr. Yasuda's presentation, most of our trial proceedings are IPRs. You know, this is looking at fiscal year 22, the recently concluded fiscal year, and you see 96% of our proceedings in that fiscal year are IPRs compared to 4% PGRs. That's on par with prior years, again, by technology, and you heard about this in the prior presentation. Most are electrical or computer inventions. This is, again, the last fiscal year. This just shows you month by month from August of 2022 through the prior 12 months, what our filings are like. And again, you can see they're pretty steady month to month. There are some variations, but largely steady in IPR and PGR filings, but at very different levels. Here are just the last 5 years of institution rate. So this went through August. Of course, fiscal year 2022 did conclude, but by the time I turned in the slides, it hadn't quite wrapped up. But you can see that our institution rate, this is where we decide to grant a trial or not, has been in the 60% range. It's dipped down to about 56%. It was 66% as of the time of this slide. Believe it ended up at about that. This is if you count by patents. There's a couple of different ways to count. You can count by petition, or because it's possible to submit more than one petition challenging a patent, you can also just count by patent. You see that the institution rates are similar, although slightly higher if you count by patent, which isn't surprising because, again, there can be more than one challenge. Although typically it's very rare to have more than one. More than two is extremely rare. So most of the time you have 1 or 2 challenges per patent. This is just a comparison of the last 2 slides, the institution rates, if you look at it by petition or by patent. Also by technology, this is another way to look, is the institution rate by technology. This varies year to year. So sometimes the biopharma is instituted less, but last year it ended up being instituted slightly more than the other technologies. Settlements, you can see that our settlement rate is fairly steady, between about 25 to 30% overall. This graph is broken out by pre- and post-institution settlement numbers, and you can see they're roughly equal between pre-institution and post, although usually if one's going to be greater than the other, there tend to be more post-institution settlements than pre-institution. And lastly, I'm just going to show you a few outcome slides. These are all available on our website, but what you're looking at here is, again, in fiscal year 2022 through the end of the 3rd quarter, you can see there were 993 total petitions filed. Of those, nearly 1/3 were denied. That's the orange slice, where we did not proceed on to a trial. About 25% settled, although if you look at other ways that the petition didn't make it to a final written decision, you can see there's another about 6%. So roughly 2/3 of the petitions filed never make it to a final written decision. Only about 1/3 of the petitions ever filed go all the way to a final written decision. And then those 3 blue slices show you the proportion of the 3 outcomes. So 25% had all of the challenged claims found unpatentable. 6% had a mixed outcome, and 6% had all of the challenged claims being found patentable. So this is a view by petition. As I said, there are different ways to count. I'll quickly show you 2 more ways to visualize it. One is by patent, and you can see just visually the outcomes are very similar, with approximately 1/3 of institutions being denied, slightly less than that, slightly less than 1/3 settled, and slightly more than 1/3 going all the way to final written decision, shown by the 3 shades of blue. But again, the total proportions are on par with the outcomes if you count by petition. And the last view I'm going to show you is just outcomes by challenged claims. So this just looks at claims challenged. You can see that in the first 3 quarters there were almost 15,000 claims that were challenged, and once again about 1/3 were denied institution. About 1/3 or less had settled in some form. They never reached final written decision. Only a little bit more than 1/3 ever reached final decision, and as of after the final written decision, about 9% were found patentable, about 30% unpatentable. So that's just sort of a snapshot of the outcomes of the IPRs, and so that concludes my presentation. Thank you again for your attention.
バレック首席審判長でございました。ありがとうございました。続きまして、欧州特許庁技術審判部門、インゴ・ベッケドルフ部門長です。それでは、ベッケドルフ部門長、どうぞよろしくお願いいたします。
Thank you very much again, and I will try to keep the time. Therefore, I might skip a couple of slides. Starting immediately with the legal basis for the appeal proceedings, I will cover slightly different topics than my two predecessors for a simple reason because the appeal proceedings before the EPO under the EPC are a bit different, and allow me to explain why this is the case. First of all, the legal basis for the boards of appeal and their proceedings are Article 4 and Article 15 of the European Patent Convention, the EPC. In Article 4, you see that the European Patent Organization has two organs. That's the European Patent Office and the Administrative Council. The European Patent Office is the one of which the boards of appeal are part of, but they are a bit separate, not completely separate, but they are separate and with a degree of independence. And we are mentioned then also in Article 15 of the European Patent Convention. You see there the litera F and G, the boards of appeal and the enlarged board of appeal coming after the different sections and divisions of the what I call the administrative part of the European Patent Office. Now coming to the appeal structure. What you can see here, you have the line in the middle, the horizontal line in the middle. Below that line, you see the administrative part of the patent grant procedure. That is within the patent office, within the different sections and divisions of the patent office. I'm not explaining the different bodies there, but I think the names are already clear. Receiving section, examining section to decide on grant, opposition divisions to decide after grant, and the legal division for some legal aspects. All their decisions can be appealed to the boards of appeal, being the first and final judicial division instance under the European Patent Convention. That distinguishes us a bit from what you just heard about the JPO and the US Patent Office. We have no further appeal. We have the appeals heard before the boards of appeal, be it the legal board of appeal, the technical board of appeal, and then the enlarged board of appeal with a specific composition and specific competence to which I will refer on a later slide. Again, there's no further appeal, and even after the coming into force of the Unified Patent Court that Dr. Bacher mentioned yesterday to be next year, become next year the reality, what we call the UPC is not a higher court above the boards of appeal, but it's a parallel court. That means additional challenges for us to avoid that there's any fundamental difference in our case law. The internal structure of the boards of appeal, you can see here. We have a president of the boards of appeal as the head administrative, but also judicial head of the boards of appeal. And then we have the different boards. The enlarged board I already mentioned, the legal board as well. 28 technical boards of appeal. They are divided into 4 main technical sections, mechanics, chemistry, electricity, and physics. And then we have a specific specific board, that's the disciplinary board of appeal that I will mention only very briefly. This hears appeals from candidates to become patent attorneys and who failed to pass their exams, their qualifying examinations to become patent attorneys before the EPO, or even some disciplinary actions against patent attorneys. And we have a couple of administrative services, of which I mentioned in particular the legal service, consisting of legal advice to the President of the Boards of Appeal and the legal research. That's the one that might be well known to the users, because they publish what we call the case law book. I will come to that in a later stage as well. The technical boards of appeal, they consist of either 3 technical members plus a legally qualified member, or in an extended composition of 3 technical members and 2 legally qualified members. They hear appeals against decisions of the examining divisions refusing a patent applications, or decisions of the opposition divisions, either by revoking the patent, by dismissing, rejecting an opposition or several oppositions filed against an appeal, or by what we call interlocutory decisions, where the patent was held to meet the requirements of the EPC in amended form, i.e. in different form than the form in which the patent was granted. Here we have per board an average of, in 2021, of 121 cases. A board usually consists of 1 chairperson. The majority of the technical boards are chaired by a technically qualified member, with 4-5 technically qualified members, and 2 technical boards are chaired by a legally qualified member, of which I am one. And here we achieved an increase in our production over the last 5 years, by 55%. The Legal Board of Appeal hears appeals against the legal division when it comes from missing time frames, or for a case that was well known, whether artificial intelligence can be an inventor, an applicant of a patent convention. There was a decision, or 2 decisions rather, published in summer this year. The Legal Board consists of 3 legally qualified members. Those legally qualified members are at the same time also members of technical boards of appeal. The number of cases settled by the legal board is rather low, due to the lower incoming number of appeals. The disciplinary board of appeal I skipped, because I already mentioned the competence of it, and now I come to the enlarged board of appeal. The enlarged board of appeal is responsible for deciding on points of law referred to it either by a board of appeal or by the president of the boards of appeal, and also since the coming into force of the first reform of the EPC 2000, on so-called petitions for review. First of all, on the referrals, what we call the referrals, where points of law are referred to the enlarged board of appeal when it comes to the interpretation of the EPC. Again, this can be done by a board or by the president of the EPO, and in that case, the enlarged board consists of 5 technically qualified members and 5 legally qualified members and 2 technically qualified members. Among those 5 legally qualified members, there can be up to 2 national judges, what we call external legally qualified members. That's something that we use quite frequently, to have at least 1 external member also in the composition, to allow a better harmonization of the patent law beyond the borders of the European Patent Office, and to try to harmonize also the application of the patent law of the EPC in the contracting stage. Currently, we have 3 pending petitions, 3 pending referrals. That's a referral on the issue of plausibility of a claimed technical effect, and the 2 other ones, the G1 of 22 and G2 of 22, concern the right to priority. They are still pending, but at least in the first one, the case G2 of 21, the oral proceedings will be held on 24th of November, and they will be streamed so everybody worldwide could follow the oral proceedings in that case. In last year, we decided 3 cases. Among those is the one that I already mentioned in my first presentation on oral proceedings by video conference, but there were also 2 decisions on substantive patent law, on the patentability of computer-implemented simulation, and also on double patenting. And the pending cases I've already mentioned. The petition for review, that's something that was introduced in the year 2000 and came into force in December 2007. This is some system of internal correction where in the proceedings, in the appeal proceedings, a fundamental procedural violation occurred. Somebody was not given its full right to be heard. A request has been overseen for whatever reason. Then the party concerned can file a petition for review to ask the enlarged Board of Appeal to review on procedural issues the appeal procedure, and then either to set aside the decision of that board. Usually any decision of a technical Board of Appeal, of the legal Board of Appeal, are final, with a legal effect, directly with a legal effect, but with this petition for review proceedings, the enlarged board can set aside that legal effect and can reopen the proceedings before the board. There are a number of reasons why this can be done. The majority of cases is decided on the question of whether or not the procedural right to be heard has been observed by a board or not. In these proceedings, the enlarged board is composed of 2 legally qualified members and 1 technically qualified member, or in an extended composition by 2 extra additional legally qualified members, making then the combination of 5 members. We have a 2-stage procedure here to first filter to see whether there's any substance in the petition of review heard by the 3-member composition, or if that composition considers that there is substance, then the case will be transferred to a composition with 5 members. Last year we settled 12 cases in this case. The overall figures. Here we, in 2021, we received 2,200, a good 2,200 appeals. We were able to settle more, fortunately, due to the overall circumstances. I already gave you the figures of the pending cases this year, even below the 7,000 threshold. And you see again what I mentioned earlier, that there's still an issue with the pendency time. And if I may, from a personal point of view, if I may say so, I'm a bit jealous when I heard the pendency time before the JPO Trial and Appeals Division and before the PTAB, but at least we understood the story and we understood the message, and we are striving to settle that. We have 256 members, staff in total, and that means that the majority of which are members, what we call our judges, we call them members, legally qualified, technically qualified, 28 chairs, and then also the president of the Boards of Appeal. Now let's move to the aspects of the appeal procedure. I start on the upper row with the filing of appeal. Before the filing of appeal, if you remember one of my earlier slides with the difference between the administrative stage of the patent grant procedure before the administrative divisions of the EPO, and then only on a second level the appeal proceedings, we are now on the second level. This procedure starts with the filing of the appeal, for which there is a time limit of 2 months after the notification of the decision of the examining division, opposition division, or of the legal division. And then only in what we call ex parte proceedings, i.e. appeals against a refusal of the grant of the patent by the examining division. An examining division is demanded, is requested under the EPC to review its decision internally before the case is transferred to the boards of appeal, because the examining division might identify any problem, be it a procedural problem or a problem on the substance of the case, and might take the case again to continue the examination. After that, and for all opposition appeals directly to the appeal boards, then we do a admissibility check for observing the time limits, for paying the right amount of fee, for being a party to the proceedings, and so on. And after that is done, the examination of the appeal on its merits, on its substance starts. And in the majority of cases, this includes also an oral hearing before the boards. So after the oral hearings, or actually in the almost 100% of the cases, the decision, the order of the decision is already announced at the end of the oral proceedings, and only afterwards the fully reasoned decision will be notified to the parties, and potentially with the additional petition for review if a petition for review is filed at all. We work now under a new version of the rules of procedure. We call it the revised version of the rules of procedure 2022 that I mentioned earlier. So I will try to concentrate only on the important points and how they influence the processing of an appeal before the boards of appeal. When this revision was adopted by the boards of appeal committee and approved by the administrative council, there were in particular three main objects: to increase the efficiency of the processing procedures before the boards of appeal, to harmonize the case law, and in particular to make our case law, our decisions more predictable to the parties, so that the parties can adapt their procedural strategy to come to the outcome they would like to see. All these three objects surround the overall objective of having a high quality of our decisions. So I'm trying to skip now a couple of pages. I can start with this page and also the next page, and I will try to put everything on information on this slide. As I already said, this revised version came into force on January 1st, 2020. We had a couple of transitional provisions to deal with those cases that were filed before that date, but were then dealt with after that date. A first measure to make our processing more predictable is the publication of an annual list. Every year, every October, we publish the list of the future cases for the next business year. i.e. this month we publish the cases that are to be dealt with in the next year, 2023. To allow the parties to already prepare that their case is now due to be dealt with before the boards of appeal. What has been underlined there as well, that the proceedings before the boards of appeal are a judicial review, or review in judicial member. It should not be a repetition of what has been done before the examining divisions, before the opposition divisions, i.e. before the examiners, but we review what has been decided there, and this gives limitations to what the parties can do before us as well. Already to say at this point in time, this does not exclude filing new requests, does not exclude to file what we call auxiliary requests from the side of the patent proprietor. This can be done throughout the proceedings, also before the boards of appeal, but the later it comes, the later the filing comes, the more difficult it will be for a party, for a patent proprietor or an applicant to get those new requests being admitted into the proceedings. But this is also true for the other side, for the opponents. They have to stick to what they submitted before before the examining divisions, before the oppositions divisions, and should not amend their case vis-à-vis the proceedings before the opposition proceedings. However, they can do that. And again, as a kind of guideline, the later they do, the more difficult it becomes to get it admitted into the proceedings. And the last new point that I would like to mention on this slide is that the boards are now asked, under the revised version of the Rules of Procedure, to issue a communication when summoning to oral proceedings in order to inform the parties of the assessment of the case by the Board of Appeal, to allow the parties to react to it at the oral proceedings, to inform the board whether on which points they disagree, and to concentrate the oral proceedings on these issues. So then I go through, because just check that I haven't forgotten anything. And that was done. Last sentence. The proceedings end either with a decision rejecting the appeal, allowing the appeal, for example, by revoking the patent, by dismissing the appeal, or the case can be remitted to the Department of First Instance, to the EPO department, either to continue with the proceedings there for further decision, or with the order that the patent should be maintained in a specific form that the board finds to meet the requirements of the EPC. It's not the board that does the publication; it is then the office that does so. So, and that's it. Thank you so much. On the last slide, you will only see some information where some links where you can find more information. Thank you so much.
ベッケドルフ部門長、ありがとうございました。以上で特許権に対する無効異議制度の実情を終わります。